Yes.
May it please your lordships. In this appeal, I appear instructed on behalf of the appellant mother, who is present in court, and I appear together with my learned friend, Miss Anita Guha. I should say that neither Miss Guha nor myself appeared in the court below, and that since the hearing in the court below, before Mr. Justice Poole, there's been a complete change of the legal team. For the father, who appears on the live stream, although he is in this country and had contact with the children yesterday, on behalf of the father, there appear my learned friends, Mr. Edward Devereux, King's Counsel.
Yes.
And my learned friend, Ms. Mevish Chowdhury. Ms. Chowdhury appeared in the court below.
Thank you. Just give me. Yes.
As this is a children's case, it's a case which involves two children, a boy who is aged 11 and a girl who is aged 8, who I'm not going to name unless my lords think it is appropriate that I should.
No.
Is
the judgment below published? It is.
I believe it is. I looked at my learned friends. Yes, it is.
Right.
And, my lords, were this a hearing that was not being live streamed, as this one is, your lordships would make, I suspect, a direction in respect of publication. Subject to my lord's view, there is no reason why that direction should not be given, simply because there are observers on the live stream.
Right. So you want me to say that no publication must identify the children or the family concerned in these proceedings. Can you help me as to why that's why I asked about whether the judgment was published. I think, certainly on the page 53 in the bundle we have, it says re A and B children return order UAE, and then the specific emirate in the UAE is not identified.
That's right.
Was there a reason for that? Or did that just happen?
The judge referred to it by a single letter.
Yes.
I had a brief discussion with my learned friends about it, and I understand it just happened. I'm content to refer to the country either by an initial letter or by a descriptive. My lord has just referred to it with respect rightly as an emirate, of which of course there are many, but I'm in the court's hands as to what is most convenient.
Is there any reason why it shouldn't be identified?
Not that I can see.
Right,
but
thank
then
you.
I
Yes?
leave that to my learned friends. Of course, my lords, at the risk of cutting across them, there was a certain amount of expert evidence as to the
Yes.
laws of that jurisdiction,
Yes.
which are
And
specific to that jurisdiction.
And the person who gave that evidence is identified and named?
Yeah.
I don't know, but
Yes.
maybe is only an expert in that specific
I think
emirate.
that I think that expert has solid links with
Right.
that jurisdiction, but I was going to avoid, for the avoidance of doubt, naming the expert if I could. There's only one expert, and there's a CAPCAS officer whose name is probably not sensitive information.
No, but sorry, so again, insofar as the published judgment is concerned, because we have in the bundle, and I haven't compared it to how it's published, in the judgment we have, the expert is identified.
Yes.
Is it the same in the published judgment? Yes?
I believe so.
Okay. Yes, Mr. Devereux. Any reason why the specific emirate shouldn't be named? I mean, not this, it just makes it easier.
No, it makes it easier.
Yeah, okay, thank you.
And that means the expert as well.
Well, the expert is identified.
There's
There's no reason not to give the expert her name, because it's in the judgment.
Indeed it is, my lords.
Yeah.
If
Okay.
I don't name names, I hope I'll be forgiven.
Don't worry at all. No,
Probably
you don't have to. It's just there's no reason not to.
A discipline, lest I fall into the error of naming the children
Yes.
parents.
Yes.
My lord, this appeal with leave by Lord Justice Baker, on some 9 grounds, of which he made a caveat on the last ground, which related to habitual residence.
Yes.
Where he was not making an indication as to prospects, is against the judgment of Mr. Justice Poole, by which Mr. Justice Poole ordered the return of the 2 children with whom your lordships are concerned to Dubai. This was a non-convention return because, of course, Dubai is not a member state of any relevant international convention. And this appeal revolves around, as its headline points, the approach which the judge took to the determination of this as an inherent jurisdiction return, with particular reference to some headline points. One of them being that there were allegations of domestic abuse made by or on behalf of the mother, and that those allegations involved some allegations of physical abuse, supported by photographic images, and also some references to pinching or slapping of the children, but also to allegations of non-physical abuse and coercive control. The question was, and in this appeal is, what is the correct approach where evidence of that kind is led to the evaluation and determination of a non-convention return case? The judge in this instance decided that he was not going to take any oral evidence from the parents, although they were available, and decided that he was not going to engage in fact-finding. Therefore, there was not an evaluative exercise which was incidentally one pursuant to the provisions of Practice Direction 12J, a practice direction I suspect very well known to 2 of my lords, but it is, and possibly the 3rd, but my lord, it is the direction which is detailed and which has been the subject of a great deal of litigation, including in the Court of Appeal, which gives judges guidance as to what to do where allegations of domestic abuse are made. The judge's approach also engaged with the domestic law of Dubai.
Before you leave, you say this case raises the issue of the correct approach to the evaluation and determination of a non-convention case when evidence of domestic abuse is adduced. In a similar form, what's your headline argument or principle that you say, if there is one? So what do you say the correct approach?
I wonder if I might come to that, because I suspect it's not going to be necessarily elucidly simple.
Right.
But I'll make an attempt, but I hope, my lord, I'm not going to be held to the precise words of this attempt, which I suspect may have to vary.
It's a significant moment. If you're saying the judge was wrong, but you can't say what he ought to have done in terms that we can readily understand, how is he meant to understand it?
That's easier, my lord, with respect. What he ought to have done.
No, yes, that's what my lord is asking. So what is the correct principle that the judge failed to apply?
My lord packaged it differently. What the judge should have done was to either engage in a degree of fact-finding or to have case managed the case so that the evidence was brought out with greater clarity. But my lord, I don't, I think, resile from saying he should have engaged in fact-finding, and that in the light of that fact-finding, he should have gone on to make whatever decision was appropriate, informed by a full understanding of whether there was domestic abuse in this case and what its application might be. The reason, my lord, or one of the reasons why we say that, and my lords have been taken in the skeletons to the observations in NY in the Supreme Court, and in particular, my lords, at paragraphs 50 and 59 of that authority. In this particular case, there is an obvious relevance because the evidence which the judge had before him was that in the jurisdiction of Dubai, whilst there was a system by which the criminal courts will engage with allegations of domestic violence, that is physical domestic violence, where those are supported by medical reports and similar extrinsic material, those courts will simply not engage at all with what we know as domestic abuse, that is, including non-physical coercion and abuse. And as the mother is alleging that, if she has to return, and if the children have to return to Dubai on the basis of an inherent jurisdiction return, which ordinarily is a return so that the welfare issues can be determined in the court of that jurisdiction, not this jurisdiction, there will be no possibility of that occurring, and no possibility, therefore, we say, of judicial protection for the mother and the children.
But trying to put this in recordable form.
Yes.
When you ask the question, what is the correct approach where evidence of this kind is led in a non-conventional case, is your submission to give proper weight to the fact that it may not be possible for it to be investigated in the other jurisdiction? Is that the essential point you're making? Because your answer so far, which is what is the correct approach, to order a fact-finding, is not an error of approach. That's to contend that the judge simply came to the wrong conclusion. So is your answer to the question that you posed that the correct approach is to take account of the fact that there isn't a fact-finding jurisdiction in the other country?
Or I might...
otherwise, what is the correct approach?
I don't demur from that, but I may go further and say that if the result of a fact-finding... No, my Lord, I go back on myself because I'm falling into the same error that my Lord considers that I fell into, that it's not a point of principle, that making a summary return is something that a judge should not do in the event that there are allegations of domestic abuse which cannot be dealt with in the courts of the other country.
So that's the approach that the judge ought to have taken. I'm only trying to see what target you're trying to hit, and we'll find out whether you hit it or not. But at the moment, we don't even have a target in my mind as to what it is that you're setting up as the answer to the question.
Well, then I must do my best to help.
Right. So,
but my Lord,
is what you've just said, which is that a judge should not make an order for summary return where there are allegations of domestic abuse that cannot be dealt with in the other country,
unless the judge has investigated those allegations himself.
So, which means that there must be a fact-finding hearing. Is that it?
So that's a blanket principle, i.e. a start principle, that in every such case there needs to be at least a fact-finding hearing.
I must perhaps hedge that because of the words in NY. and relevance is a consideration.
Well, yes, and also welfare is inevitably going to entail a balancing of a number of competing factors, or sometimes competing factors, or anyway, a number of factors. And you seem to be trying to elevate one factor as being determinative of the approach the court should take.
My Lord, I was going to complete what
Sorry.
is, I fear,
Sorry.
a rambling and not a rambling recital, and not quite as precise as my lords would like from me at this stage, which is that unless the fact-finding investigation results in a conclusion that welfare is not offended by the summary return. So one can have fact-finding in a welfare hearing.
Yes, but you're still saying there needs to be a fact-finding. You're saying procedurally it's necessary in every such case for there to be a fact-finding hearing in this jurisdiction.
Where allegations are raised,
Yes.
and where there is evidence, they cannot be dealt with in the other jurisdiction.
Yes. Well, that speaking for myself, clarifies what your target is, and that the consequence of that, it would have to be accepted, is that in a case where return to a jurisdiction which didn't have a fact-finding possibility is in question, we would be saying that you have to have a fact-finding hearing here, even if you wouldn't have a fact-finding hearing if this was a domestic case.
There, my lord, one looks at the terms of Practice Direction 12J.
So why doesn't that apply in spirit to this, namely that it's possible for a judge to say, well, metaphorically applying 12J to this situation, I don't need a fact-finding hearing to tell me the answer to the essential welfare question, mindful of the fact that there's no prospect of fact-finding abroad. I mean, your submission, so far as you announced it, hedged it, still amounts to the proposition that in such a case as this, there would have to be a fact-finding hearing, whereas if it was a domestic case, there would not necessarily have to be a fact-finding hearing, it would be a question of judgment.
Though we say, my lord, that in this case there would and should have been.
No, I understand that, but that's a very mundane submission, which is very important to the parties in the individual case, namely that the judge should have decided the case differently. But what you're seeking to set up is an entirely separate proposition, which is that there has to be a fact-finding hearing if there can't be one abroad. And unless you say that's not what you're contending for, it's what we have to address.
My lord, I'm sorry, I'm wearying the court, but what I can't look behind is either Practice Direction 12J itself or the observations of the Court of Appeal in Re-HN, because they provided some guidance on how to deal with these
So
cases.
is it possible for a judge in a case where there cannot be fact-finding abroad to say that there shouldn't be fact-finding here?
If he or she can negotiate the terms of Practice Direction 12J and the judgment in HN, and in particular the guidance in terms of the 6 headline points which were made in that judgment as to what the court ought to do. If the judge can emerge from that exercise and say it is not necessary to have a fact-finding hearing, then it is not necessary to have a fact-finding hearing.
Well, then there's nothing distinctive about non-convention returns, because the judge has to, by that token, carry out exactly the same exercise, but in an international context, and would be thinking there's not going to be a fact-finding hearing there, because they can't have one. And in a particular case, there's not going to be one here either, because it's not necessary. So what's left of the proposition that you first set up?
Maybe, my lord, I was misunderstood, or put it badly, one or the other. There isn't a distinction in this regard between the approach in an ordinary domestic case, on the one hand, and that in a non-convention return case. That is the point. That's the point I was seeking to make, where in this particular case, the judge directed himself, to some extent, in accordance with Re E in the Supreme Court, which, as my lords know, two of my lords well know, is the approach that was predicated as correct in 1980 Hague Convention cases, where by custom there is no fact-finding, and certainly no fact-finding on Article 13b defences, which can include allegations of domestic violence or domestic abuse. We say that that cannot be elided with the correct approach where allegations of this kind are made in a non-convention summary return application. I'm not trying to say, my lords, that there is a different and tougher test in a non-convention case than in a domestic case in this country. It is the same.
Thank you.
Thank you. If I move from there in my headlines,
Yes.
Another area that the judge was faced with was a classic jurisdictional difference between Dubai and this country. And that was in respect of relocation. In this country, as my lords will know, relocation cases take place with the best interests of the subject child or children being the first and paramount consideration, although there is a great deal of law in the background to that it is now settled is the paramountcy principle of those applications. The clear evidence given by the expert, which became clearer orally even than on paper, is that in practice there is not a realistic ability to move the Dubai court to make a relocation application by the mother. It can simply be blocked for so long as the father is living in that particular emirate, and best interests, therefore, do not really enter into it. The expert was very clear, there would not realistically be a relocation jurisdiction. What the learned judge, the trial judge, was not doing was trying a relocation case. Nevertheless, what he did was to say that he concluded that by English jurisdictional standards, any application made for relocation by the mother would not have substantial prospects of success, and therefore that was not an obstacle to a summary return. The case of J in the Supreme Court, in the House of Lords, now an old case, deals with differences of jurisdiction, and of course they need to be relevant differences for them to be material to the consideration of whether or not there should be a summary return. My lord, we say in this case that without fact-finding and without an evaluation, particularly where there were allegations of domestic abuse and coercive control, it was not possible for the judge properly to say, in the hearing that he conducted and within the judgment in which he expressed himself, that he could rule out in the way that he did a reasonable prospect for the mother in these jurisdiction terms making such an application. And if she desires to make such an application in a summary return for litigation, the blank failure of the Dubai jurisdiction to afford her the opportunity should have been something that meant that he did not make a summary return. But in any event, he should not have drawn the conclusion that he did about no substantial prospects of success. So, my lord, that is another area, headline area, in which the judge is criticised by us in this case. A third headline area is that the judge...
The first two being domestic abuse and relocation.
Yes.
Yeah, thank you.
A third headline area is that the judge, when trying the case, elided two approaches. He elided the approach in Re E, which I have mentioned, and in Re E, as again two of your lordships are well aware, but one may not be, and so I give the headline of it, that when trying a Hague Convention case in which it is said that a return would place the children at grave risk of physical or psychological harm or in an intolerable situation, and sometimes that is articulated as being through the effect of placing the primary carer parent, which there is no doubt this mother is, in such a situation, and it having a redounding effect on the welfare of the children in her care, that there should not be fact-finding, but that to compensate for that, the judge must accept the retaining parents' allegations at their highest. That is, there mustn't be an attempt to evaluate them and discount them in terms of their merits, but to say, well, this is the way it is, and now I must look to see what the protective measures are in the other country.
Would it be right to describe it as their reasonable highest?
I wouldn't be so sure of that, my lord, because that of itself entails a degree of evaluation. I might go this far, that, my lord, if the allegations are things which are self-evidently completely nonsensical, and it's perhaps hard to find an example, but it's something where a factual allegation is made that is disproved by the evidence itself that's before the judge so comprehensively and so irrefutably that it is impossible to take the allegation at all seriously. But that, my lord, will seldom apply and doesn't apply in this particular case, where allegations of domestic violence and domestic abuse are made by way of example, where what is said by the father in terms of, for example, the images which show, the mother says, harm to her on more than one occasion, the father says, well, I don't know what they are, and then the father says alternately in respect of one of them that they might be or that they are insect bites. That is not the sort of material where a judge can say, well, I dismiss that. I can't take that as being remotely credible, and therefore on a re-E evaluation I'm going to discount it. The court must, if it's not going to fact find, simply take the allegations at their highest, and if the court does, and if there are allegations as there are in this kind, the court must look to see what the effect of a return would be, potentially, and what the protective measures might be. And of course one knows that if the Dubai court will not give credence to, will not look at in a best interests way or otherwise non-violent allegations, well, it follows that the protection is going to be limited. My lords, the same, of course, applies to other aspects of the case. If the judge, on the other hand, is not going to take a re-E approach, and we say that taking a re-E approach is to apply Hague Convention principles in a way that the House of Lords deprecated in Re J.
So you're saying he elided the re-E approach with the Re J approach?
He elided it
With the Re J approach?
A qualified degree of not fact-finding, because he wouldn't, but nevertheless analysis of what he thought was the likely position.
Sorry, I'm going to try. He elided two approaches. One, you say the re-E,
yes,
with
the approach, with a flawed approach in a non-convention case, where Hague Convention principles are not permitted, so that without doing the fact-finding that he should have done, he purported to make evaluations. We also say, which meant that he wasn't faithful to the re-E approach. And if one looks at the judgment, the judge sits between the two stools.
Well, yes, it might be said that he wasn't applying the re-E approach for the reasons you give. But if the judge, you say the judge, one of the questions the judge has to ask is whether he should undertake a fact-finding investigation. That would surely require some form of analysis of the allegations.
It would.
And for the purposes of that analysis, how does the judge approach the allegations that have been made? Balancing all the evidence, taking them at their highest, looking at what does he do?
He doesn't take the allegations at their highest because his approach, for example, to the domestic abuse, plainly does not take them at their highest, insofar as he does make that evaluation. And we note that he doesn't mention Practice Direction 12J at all in the four corners of his judgment. And that in terms of relocation, and another example, he makes the relatively bald statement that he doesn't think that there'd be substantial prospects of success, without looking at the nature of a case which the mother might seek to advance, to relocate, which would relate, among other things, to her allegations of coercive control. But, my lords, moving on from there...
Before you do...
Yes, ma'am.
I'm at the moment not clear what your complaint is about a judge who did apply re-E to a situation of this sort, because re-E makes an assumption in favour of the truth of the allegation for the purposes of a summary conclusion. So what's wrong? What would be wrong with that? That would seem to be beneficial.
It might be beneficial to a respondent, but with a non-convention child abduction case, some of the assumptions in a Hague Convention case cannot be made.
I understand it, but I mean, this is not an exercise in just trying to trip judges up.
Oh, no.
But what I don't understand is where you're faced with a judge who says, I should make a reasonable assumption in relation to the maximum level of risk. One can argue about whether that's a correct re-E direction or something watered down, but take a different judge who says, I know that this is a non-conventional case and that E is a conventional case, but I'm going to take the allegations at face value, to use a different formulation.
Yes.
What could possibly be wrong with that?
Two things, my Lord.
Right.
The first is that because the unalloyed welfare, uncompromised welfare interests of the index children are paramount, that might not allow an investigation which would yield a different result than the result which would be forthcoming if a re-approach to the allegations was pursued.
Can you put that in different words, because I don't understand what you're saying?
A re-E approach, on the face of it, protects the respondent parent.
Yes.
What it does not do is to allow challenges to that approach within the proceedings, which, if made and adjudicated upon...
Challenges by whom? About what?
Challenges by the other parent, and challenges, if necessary, by the child.
But why? I mean, you're here representing the position of the respondent parent,
Yes.
and re-E is giving the respondent parent a reasonable maximum of their case, untouched. So are you saying that your case might get even better if it was cross-examined by the other parties? I mean, isn't it for the respondent parent to put up their case?
My Lord was addressing me, as I understood it, on principles. And the principle of why a re-E approach is not appropriate in a non-convention case is partly with respect, as I've described. That doesn't assist me. That's not something I'm...
Because the re approach only relates to a section of the case,
Yes.
which is the allegations of harm that are being put up. Welfare will be a wider calculation in a non-conventional case. But it would seem that re-E, as it were, secures for you that part of the case which relates to harm.
My Lord, it's difficult, we would say, to separate out the two. And in a non-convention case, the court's approach should be holistic.
And that leads you back to the same parking place, which is that, therefore, there's got to be a welfare fact-finding hearing?
Unless by negotiating HN and 12J on allegations of domestic abuse, the court could, in a domestic case, find a different way of doing it. But, my lords, that is one. I said there were two areas. And, my lords, the other area is this, that if the court operates on the re-E principle, that is operated in Hague Convention cases where certain assumptions are made about what in normal cases the other jurisdiction is able to do. It is a convention jurisdiction. There is in this case a good deal of evidence about the other jurisdiction, which means that looking at protective measures in the same way as can be done in a Hague Convention case, or if I put it in another way, in the ordinary form of Hague Convention case, where one will not have ordinary evidence of the kind there is here about the inability of the other jurisdiction to embark in certain important particulars on child-centred remedies which would be available in this jurisdiction. Well, that makes a difference. But, my lord, what we say that the judge did was to blur a re-E approach, which I don't resile from saying wouldn't have been right on the authorities, because it is a peculiarly Hague Convention creation, and a creation of English judges in that context. What he went on to do was to embark on consideration of what's been described in this case as the settlement agreement. And in doing so, he moved from trying a non-convention abduction case, I remind myself, not therefore trying within the boundaries that he appears to have set himself, the issue of domestic abuse, or indeed the issue of relocation, but nevertheless having expressed himself as forming views about their relevance, he turned to consider the so-called settlement agreement, which is something, and if I have its history wrong, I hope I will be forgiven, and I know my learned friends will correct me, is something that emerged during the course of the hearing, didn't reach a final form until after the hearing, but which the judge expressed as being a prerequisite to a return. In the course of his evaluation of relevant matters, the judge looked at one particular aspect of that settlement agreement, that putative settlement agreement, and that was in respect of contact, where the judge, against, we would say, a controversial background between the parties, and submissions which indicated a controversy between them, made a provision which in round terms was for there to be contact between the father and the children following a return, but that contact to be supervised, but that supervision in turn only to be for a limited period. And that was contrary to the submissions made on behalf of the mother. There the judge went, we say, selectively and on an inadequate basis into the evaluation of a substantive welfare issue. And what he did was to make his determination, which was a relatively summary determination of that issue, without having investigated the allegations made by the mother of domestic abuse, and indeed the allegations which the children appeared to make of pinching and slapping.
It's coming back to the judge was not properly in a position to make that decision because he hadn't sufficiently investigated the evidential background.
But in embarking upon that, again, he was purporting to engage in what is a hybrid hearing. It was part a consideration of the re-E approach, in part a consideration because of the way that he discounts the domestic abuse of a non-convention approach, but we say wrong in his approach to that because of 12J.
Can you run with the other parts of the settlement agreement? Did they deal with what used to be called residence?
Custody.
Custody.
Custody, yes.
So it was to provide a framework for the parents and the children, which was to be approved by the local court, so that it might be viewed as being in part protective
Yes.
of your client.
Yes. Yes.
So that there was a court-approved, as I say, framework that would provide protection for your client. For example, the children would not be removed from her by the father. So you're saying the judge wasn't in a position to make any decision about that, and indeed he shouldn't have gone there, or should have said no settlement agreement, or settlement agreement that didn't include contact, or what?
If the judge was going to determine a welfare issue with the intention that the product was built into the settlement agreement, he should have done, he should have performed that exercise without blanking out important parts of the evidence.
Right, so again, the judge wasn't in a position to make a decision as to custody, for example, without undertaking further factual investigation.
What the judge could do was to look at what protective measures might be available. That is a distinct exercise, and I couldn't complain about that. The judge, having received the evidence of the expert,
Right.
could legitimately say, well, if I am to return, what can we do about this?
Right,
What can we do
okay.
about this? And there are some areas which the settlement agreement addresses.
So the judge was in a position properly to evaluate those aspects of the settlement agreement, but just not contact. That's what you're saying.
If there was an offer of a settlement agreement, which it looks as if there was, which would deal with matters such as custody,
Yes.
and the father not removing the children from the mother, then the judge was entitled to take
Right.
that
Okay.
into
So
consideration.
it's simply the contact.
But what the judge went on to do was to resolve welfare issues with the intent that his determination of the particular issue, the issue of contact, should make its way into the settlement agreement. And as it happened, it was a very, very important area, because it was the area, or an area, in which the allegations of domestic abuse, allegations made by the mother and by the children, might be met in a practical way in terms of ongoing activity. That leaves aside entirely, of course, what I might call the HN approach, which is that the sequelae of a history of domestic violence and domestic abuse may have a long and corrosive life, and it is not right at all simply to say, well, actually the majority of these allegations, or the allegations of physical abuse, dated from a period before the separation, and therefore I'm going to ignore them as irrelevant. I'm going to discount them.
What's the conclusion? Not just that there should be a fact-finding hearing, but you say in this respect, effectively, there should be a full welfare hearing. And that, nothing less than that sounds as if it's going to satisfy you.
My Lord, I shouldn't jump more fences than I need at this stage. The evaluation through the prism of 12J and HN needed to take place and simply didn't take place. If the result of that, as is likely, we say, was that with the children and the mother making the allegations that they were, a consideration of welfare in the context of making long-term arrangements for contact. And these were long-term arrangements in the settlement agreement, required welfare to be properly addressed. What the judge was doing was stepping entirely out of the arena of a classic summary return case, which is a return for long-term welfare issues to be decided in the other country, and determining selectively himself.
I'm sorry, sir, I'm not understanding. Are you saying that, therefore, there needed to be, whether you call it a proper welfare investigation before the judge ordered any form of contact?
Yes, my lord, that in the circumstances of the case, where the judge's order predicates non-supervised contact to the father after a relatively short period.
Right. And what does that involve? It involves considering under 12J, as illuminated by HN and other cases, whether there needs to be more evidence. If there does, calling for it.
Yes.
If there doesn't, making a decision based upon what one has.
Looking at such fact-finding as is necessary.
Yes, but
Yes.
The point that the judge was hard up against was whether he had enough evidence or not to make the determinations, various determinations that he made. He decided that he did, and you're challenging that. But surely this is what you're really challenging is an evaluative judgment. If you're saying there must, before one orders contact in circumstances of this sort in the return country, be a proper welfare investigation or a full welfare investigation, or however you choose to say it, then could you articulate that so that we understand what your target is?
Lord, I've already sought to address it. I'm not sure I'm going to be able to address it better if I repeat myself. But what I am, my lord, hopefully permitted to do, is to take the court to the way the judge dealt with these issues and point to what we say are inadequacies in that context, in the judgment. And, my lord, I was on the point of contact, and there the contact was determined, my lord, in a summary way. And it shouldn't have been determined in a summary way. It was not a summary issue. It was not the return issue. It was an issue that the judge was dealing with substantively. And he did it without investigating at all the continued effect of the allegations made upon the mother and the children in this context. And the settlement agreement of itself was viewed by the judge as being an absolutely essential element of the return decision.
I'm sorry to ask this question, but could you identify for me the provision that you've been directing these submissions to, the provision in the settlement agreement? But I take it that you're talking about the annex to the order.
Yes.
138.
Yes. I was looking, my lords, at the judgment also.
Yes.
And there it's on page 70, where the germ of it is to be seen at letter E. Direct contact on special occasions during school holidays and during weekends, and the agreement, that agreement, an agreement on contact, must be reached within 2 weeks of this judgment, and the terms included in the settlement agreement And then one
So
goes...
it's the direct contact element that you're talking about, I understand.
So that, my lord, is the...
And that does find its way into the annex.
Is the problem. And, my lord, there the judge, in seeking to impose a solution, was not addressing the burden that he had to address in making a welfare analysis.
I mean, your submission, as I understand it, is that this isn't an agreement. To a non-family lawyer, the idea of ordering parties to agree something is a bit odd.
I'm afraid, my lord, that to a family lawyer, it is also a bit odd. It's not.
But the provision is that the return is conditional upon an agreement.
Yeah, but also an insistence that an agreement will be reached. And so, my lord, yes, we do say that is very troubling indeed, because one cannot impose an agreement, particularly in an area where there is a hot controversy which engages serious and significant welfare considerations.
There was I fully understand the point about the label for this document, but there is a string of email submissions which relate to the drafting of the settlement agreement, which we have at the back of our bundle.
Yes.
Do those take up, on behalf of your client, the contact point that you're now making?
I believe, my lord, that they do.
Can we look at where that is?
I need to confirm, if I may. They do, don't they? Yes, they do. Yeah. Can you give me a page reference? Yes, they do. I'm going to seek to give my lords a page reference. Mr. Devereux offers 134.
Thank you.
And, my lord, the father's document at 129. And, my lord, it's paragraph 8 on page 134. Might be of assistance.
So the focus there is not on the direct contact, but on the continuation of the third party presence. Is that
That is
paragraph 8?
That is right. And the judge determines that should have an end point to it.
Right, but I don't wish to miss something because I haven't studied this in the way that you will have done.
That's right.
But what is...
The mother was... I'm sorry, I mustn't interrupt.
No.
The mother was not saying there should be no contact, and indeed the father who came to this country for this hearing has had contact. It's a question of supervision because of the concerns and allegations raised.
So when you're making these submissions about the judge trespassing on contact matters, what you're really pointing to is the ordering of unsupervised contact. It's not an issue of direct contact, meaning face-to-face contact. That was not controversial. It's a question of whether the father is accompanied indefinitely by somebody.
That is my reading from the papers. I ought just to check to see whether anyone on my team knows better than that. That is correct.
Thank you. So the issue is supervision, not contact. And more specifically, whether supervision should be for a short term or effectively indefinite.
and the judge has made a long-term order,
A short term. Well, the supervision should be short term or indefinite, and he has said short term.
the judge has made a long-term contact order.
But that's not controversial, the idea of contact.
My lord, long-term unsupervised contact, definitely contact.
Yes, I understand that. So.
There is also some detail, but like saying 3 weeks in the summer holidays, which was not agreed by the mother either. So it's not solely the question.
Can you help us as to where that appears?
It's also...
Where does that appear?
It's also quantum. My lord, we'll see it at page 130.
Thank you.
It looks there these submissions on page 134 are referring to a draft. When it says, for example, as made clear, paragraph 12.
Yes.
Do we have that? I know we have behind this is a copy of the settlement agreement, but I assume there were a number of iterations of it or something, and they were arguing about that.
My understanding is that a draft was produced by the father's team, and I suspect it was produced either at a late stage in or even after the main hearing. But it may be that my learned friends can assist on that.
What these submissions, they're perfectly understandable submissions saying to the judge, please will you do this rather than that. So it's putting forward the case for the judge making one decision rather than another. So it's, in other words, it might be read as leaving the judge to make one decision rather than the other, rather than saying you're not able to make this decision.
The judge had put the parties in a position of requiring an agreement.
Right.
And that was an imposition. The mother's case was an opposition to a return.
No, I understand that, but it's, yes.
But even if the parties collaborated in negotiation, and therefore with a point on which they could not agree, that point was put to the judge. That did not absolve the judge from determining it properly.
Yes. So you're saying that he in essence, should have gone with the mother's position because he was not he hadn't undertaken sufficient investigation to come to any other decision. So as it says in the submission quite fairly, advocates a cautious approach or more cautious approach.
Without derogating from the mother's opposition to a return.
Don't worry, I understand that. Yes, thank you.
But again, and it's very similar to the point which I made, probably not as eloquently as I should, in answer to my Lord Justice Peter Jackson, that if the judge was going to embark upon decision-taking, following what might be called a re-E approach by analogy, I don't want to go into welfare, so I will simply take the lowest common denominator of what the parties can agree upon and go with it. Would that be the correct approach, where what the judge was doing was making a permanent order?
Right, okay.
Where the judge had required an agreement. If the parties had instead presented the judge with agreed conditions for a return, which does happen, as my Lord knows, that would have been very different. But that may be a point of relatively minor significance.
Right. Now, what you were doing, I think, was taking us through the judgment to show the inadequacies in your submission in it. Do you want? Is that taking you out of your course, or do you want to?
I will take whatever course.
No, it's
the court would.
It's just that you suddenly said, "I'm going to the judgment dealing with inadequacies," and we've had one. And I would just want to see: are you going on with that, or are we going back to something else?
Well, my
it's
Lord,
entirely up to you.
Thank you. What my Lord I had been seeking to do was to deal with headlines.
Right.
And unfortunately, their headlines ended up more like War and Peace on the front page.
I've got 4 settlement agreement as the 4th headline. Is there a 5th?
I'll turn to those.
How many more are there?
I think that's the other headline might be habitual residence. But may I just turn to my learned junior for a moment?
Or was it? No, I took it as a 4.
The last point in the grounds of appeal, and there are 9 grounds, and what
Yes.
I've done is to seek
No, absolutely.
to distill
Yes.
those, but the grounds remain, is the question of habitual residence. And I put it in this way, that the judge was disparaging of the degree to which the children and the mother were rooted in this country. In fact, the children had done 2 terms in school.
Before we go into the detail, what's the relevance of habitual residence?
I have to concede that notwithstanding its appearance in the grounds of appeal, if there was habitual residence in this jurisdiction...
Is that what the jurisdiction is based upon?
If I...
I mean, it's a non-convention case.
Yes. My Lord,
What relevance has habitual residence got?
in my own way, I'm trying to answer that point, my Lord. I have to concede that if there is, or was at the relevant date, habitual residence in this country, that would not be a bar to a non-convention return, because a non-convention return does not demand habitual residence in the other country, which is, I think, the point that my Lord was seeking to extract from me. So, yes, but it would nevertheless be a point, potentially, of some relevance if habitual residence in the European analysis indicated a degree of integration in the social and family environment in this jurisdiction.
Well,
it's a consideration.
Ground 9 is that his analysis of whether the children were habitually resident here was defective. We're not talking about habitual residence there.
Well, my Lord, my Lord is familiar with the seesaw in Warby, but the same applies whether it's habitual residence in Dubai or lost in Dubai, or not in England, or gained in England. I'm eliding those considerations. If there was an habitual residence in this country, then that would denote a degree of integration in the social and family environment here. There was evidence of such integration. It wasn't analysed fully at all.
Well, it wasn't, as I understand it, but correct us if this is wrong. I mean, your client was represented by Mr. Jarman in the court below, who was an immensely seasoned advocate in this field. And as I understand it, the point wasn't even taken. So what are we doing considering it now, apart from the fact that you got permission to advance that ground of appeal with some diffidence? How can we get into it now?
My Lord, with a little trepidation, I'll attempt to embark upon it now. It goes like this. A consideration of jurisdiction is ordinarily an appropriate consideration for any English judge to make at the outset of the case. We have put in a decision of Mr. Justice MacDonald, which, as it happens, came out on, or was made on the same day as the hearing before Mr. Justice Poole in this case. in which dealing with the position where one country is a non-convention, including non-1996 country, an evaluation of whether there is a jurisdiction here requires the application of the 1996 convention and therefore habitual residence. If that process had been undertaken, if the judge had looked at where the children were habitually resident, which was not something upon which Mr. Jarman addressed him. I don't criticise Mr. Jarman for doing that, for not doing that. He might have been more mindful of the evidence of integration which was actually present.
So does it come to this, that if the mother had made the case that these children were habitually resident here, though she didn't, the judge would have been bound to find that they were. That's what you need, isn't it, to make any progress with a ground of appeal of this sort, even if one overlooks the fact that it hasn't been argued.
I would hesitate, my lord, to say to your lordship that the court would have been bound to draw a particular...
Is anything less than that of any avail to you?
The evidence. But if the judge had looked at the question whether or not the children's habitual residence had changed, then in carrying out what we say should have been an holistic welfare analysis, he would have had his attention drawn to aspects of their integration here.
So
But
what?
Lord,
Sorry, go on.
I did say that I was cautious about this, and I'm conscious of the fact that Lord Justice Baker did not grant it a qualified leave on that matter.
But really your submission is to the effect that the judge did not sufficiently analyse the children's integration in and connection with England and Wales for the purposes of making his decision. The label of habitual residence is irrelevant. It's the analysis he undertook of, whether he sufficiently analysed those elements for the purposes of making his welfare determination. Is that unfair, putting it that way?
My lord, it is, save that if he had found that there was...
It is unfair, or it's not. Sorry.
It is probably fair.
Okay.
But even the label carries some weight, because if one looks at the position of children who are habitually resident here, that may put an element of caution into the mind of the judge.
Yes, except in 26.6, the judge said the children's situation in England is precarious.
Indeed.
And that's a finding of fact that he made.
Indeed it is.
And not really being challenged. I think you would find it difficult to challenge it. So it was, my lord says, in the face of that analysis, that conclusion, the prospects of the judge actually having found that the children were habitually resident here would seem very remote. And it's more, as I understood it, you're saying if the issue had been raised, he would have undertaken a different, more detailed analysis, which he didn't do. So it's a rather different argument. Is he didn't give sufficient weight to certain factors, didn't...
My lord, when the judge...
And I think we're probably spending too much time on it.
I suspect I am, but my lord, when the judge says that the children's situation here is precarious, that of itself understates the position on the evidence, but also does not, of course, bear in mind the comparative, especially if the mother's allegations are made out. I should say this, my lord, going back to the settlement agreement, my lords asked me about what else it did. My Lord Justice Moylan asked that. It isn't perfect, though this isn't my best point in this appeal, because there are still ways, in the light of the evidence of the expert, by which the settlement agreement might cease to have effect. And for example, on the mother's remarriage, although the settlement agreement purports to provide some security, it is not necessarily absolutely watertight.
Yes, yes.
But that is not perhaps the best point
No.
that I have to take. My lords, that was the headlines.
Yes.
What your lordships have is a lengthy, in relative terms, and relatively detailed skeleton argument from Miss Guhar, which I don't resolve from in any particular. And I should say that my advent in this case was somewhat later than Miss Guhar's.
Yes.
But there's nothing in that we
Thank
say
you.
admirable document that we seek to retreat from. What I can do, if your lordships wish, is to go to relevant aspects of that which deal with the way that the judge, in his judgment,
Quite. A critique of the judgment.
with matters. Or, my lords, I can seek, and I'm well aware of the time, and I ought probably to try to finish these submissions by about 1 o'clock,
Well, no later.
to allow my learned friends
Yes.
a suitable opportunity to respond. I could seek to answer some of the points which are made by my learned friends, or I could wait.
I think a critique of the judgment is what
Certainly.
seemed to be what you would be helpful.
Certainly, Lords. In which case, what I will do is to go to the skeleton itself. One of the areas in which this team finds itself somewhat handicapped, but it may not be a matter of particular relevance as matters turn out, is this. At an appropriate stage, transcripts of the oral evidence that was heard, which is the oral evidence of the expert and the oral evidence of Ms. Baker, were requested. Those transcripts, sadly, have not been forthcoming, despite the best endeavours of those instructing us. We have seen a note, which is of course not the same thing, and into the skeleton were put various assertions about the material that was before the judge, and this appeal is inevitably based, at least in part, on those. I don't think that those are controversial, but, my lords, I point that out. So, if, my lord, we look, I look with your lordships at the skeleton argument, and look at Roman 9, which deals with the listing.
Yes.
And the first point made is the court refused the application on behalf of the mother to hear oral evidence from the parents as a preliminary issue. At 10, in the father's skeleton, it was said the mother wishes to make an application for the parties to give oral evidence on the issues of the father's alleged violence and his behaviours, and the father's alleged inability to focus on the welfare of the children. Father submitted it wasn't a case for oral evidence, and then this submission was made by my learned friend. The issues identified by the other parent are matters not relevant to the application for summary return. This is not the appropriate forum.
Yes.
My Lord
That was the
sees-
submission that was made. What's obviously of more relevance is what is the judgment and how the judge approached it.
My Lord, the judgment, and my Lord, we see the relevant extract at Roman 12 over the page.
Yes.
What page of a bundle are we looking at?
23.
Thank you.
Yeah, that's the same as yours.
Hmm?
No,
Yes.
22.
22, I'm grateful.
22 to 23.
Thank you.
22, 23 I think for this.
Right, I see.
23 for this.
Yes.
My Lord, the judge, when looking at domestic abuse, commenced at paragraph 6 of his judgment,
Yes.
which is page 55.
Yes.
And he summarises the material that is before him.
Yes.
He is plainly focused on, in paragraph 6, to some extent, on physical injury and corroborative evidence of physical injury, and evidence, he says, of injuries to the children there is none, by which he means, of course, apart from the children saying that they were physically pinched and slapped.
I don't understand the point that you just made about being focused on physical matters.
Yes.
The whole thing is interlaced with a variety of physical and non-physical issues. One reads the 6 or 7 paragraphs, 6 paragraphs that the judge devotes to it at this point.
Yes. My Lord, I agree with respect. But the judge then goes on to deal with 2 videos, and the judge carries out an evaluation of those videos at paragraph 7. The videos appear to me to be obviously staged, in the sense that the children are not spontaneously speaking, etc. Waste of my Lord's time for me to read this out. But the judge looks at the video and makes an evaluation of what he sees. Then he turns to Ms. Baker's evidence.
Well, all this is an analysis of the nature of the case.
It's a recital
Yeah.
of the material before the judge,
Yeah.
but interspersed with
Elements of evaluation.
elements of evaluation.
Yes. What's wrong with that?
Yeah.
Because, my Lord, it's selective evaluation.
Well, yeah, well, so what? I mean, you'd have to say that it's completely the judgment overall is completely unbalanced. I mean, there's bound to be selective evaluation because you can't evaluate every fact, and so the judge is interspersing his analysis of the allegations at this stage with some evaluation.
My Lord, he is...
And I don't understand where this is going. I'm sorry about this. I'm looking at the time again. Is this the judge? What's the submission? Overarching submission.
The overarching submission, my Lord, is that he didn't, whilst he did purport to make an evaluation, and I plainly accept that, indeed I assert it, what he didn't do was to do the job properly and in accordance with the provisions of 12J
Right.
and with H&N. And there, my Lords, it's a matter really of what doesn't appear in the judgment as much as what does, and one would come to the legal framework, which is at paragraph 19 onwards. But, my Lords, before we do that, there is, on page 58, his analysis of the experts' evidence,
Yes.
which plainly forms part of the backdrop
Yes.
to any consideration, and to Ms. Baker. And what Ms. Baker said on paper had changed somewhat in the course of her cross-examination by counsel for the father. And we see that at paragraph 17. She maintained, did Ms. Baker, a recommendation that there would be a return, that a return was in the children's best interests, but she said that she was less sure about the recommendation, having heard the experts' oral evidence. And she found that one of the children had been overburdened emotionally and psychologically, and that child, the girl child's hostility to the father was of concern to Ms. Baker.
Yes.
So although the Kafkas officer gave an overall opinion, it was very much a shaded opinion.
Yes.
And so the legal framework takes the judge at paragraph 19 to the digest by Mr. Justice Cobb in J&J, which your lordships have, but we put into this the salient parts.
Yes.
So I have no need to take my lords to it. And it's at paragraph 34, Mr. Justice Cobb looks at what was said in Re NY and in Re J, which we say are the paradigm Supreme Court and House of Lords authorities, which deal with this aspect of the case. What I would say, my lords, is that Re NY plainly predates the very recent learning on the appropriate approach to domestic abuse from the Court of Appeal, the H&N case in particular. They relate to the locus classicus of Lord Justice Buckley in L. My lords, there it is, and I hesitate to regale a court in 2022 with Lord Justice Buckley in L in 1974, a world away. But in some respects, those considerations are opposite, because Lord Justice Buckley talked about a return forthwith where a case had been brought speedily to the attention of the English court, and this case was not brought speedily to the attention of the English court, and the children had been in this country for a relatively long period. And that...
when do you say that it ought to have been brought?
I'm sorry, Lord?
When do you say it ought to have been brought?
I'm not saying that it ought to have been
No,
brought
but
at a particular
I mean,
time. But there was...
the impression created is that having come over here, for one thing, there was a period of temporising and asking for extra time and the usual sort of developing scenario. So what is the period of delay that you say ought to have had any relevance at all in the mind of the court?
May I have a moment? Yeah. It was in January that the father agreed to the enrolment in school, and that was an obvious point at which he could have said, no, I don't agree to an enrolment in school, and I want to return now.
Thank you.
What Lord Justice Buckley says in the extract is, among other things, that it may be best for disturbing factors which are likely to be psychologically disturbing to a child by being kept here, should be eliminated from his life as speedily as possible. A full investigation of the merits of the case by an English court may be incompatible with achieving this. The judge may well be persuaded that it would be better for the child that those merits should be investigated in a court in his native country than that he should spend the necessary period here. And that framework, applicable to a suitable hot pursuit case, and this is not such a hot pursuit case, applicable to a case where the retention in this country is potentially psychologically damaging, is applicable to a case in which the welfare issues can be adequately investigated in a court in what Lord Justice Buckley describes as the native country. And those are all areas of doubtful application, my Lord, we say, to this particular case. And my Lords, again in the extract which follows, that the reference to the reprobation of kidnappers, but the assertion that conduct should not be penalised, welfare is paramount. So, my Lord, Mr. Justice Poole recites those matters, but we say in the way he hears the case, he doesn't apply them. He then turns to J, and again, that's familiar territory to two of your lordships, and I would be taking up time pointlessly in reciting what is said in full, but at little 2, Lady Hale said there is no warrant, either in statute or authority, for the principles of the Hague Convention to extend it to countries who are not parties. In all non-convention countries, the courts have consistently held that they must act in accordance with the welfare of the individual child.
Yes.
It must be in best interests, not because the welfare principle has been superseded by some other consideration. So there is that, and for what it is worth, it was me who was arguing the contrary unsuccessfully before Lady Hale in that case.
Well, quite. Those are rather important words given your submissions in this case. The welfare principle is not superseded by some other consideration.
Yes.
So the overarching is welfare. How the judge approaches his or her analysis of that depends on the facts of the case.
But, my Lord, so it is in any children's
Yes.
case. And so the considerations of this is a summary return case are not likely to be something which has an overarching effect on welfare.
Right, so we've read J.
It's circular.
Yes, okay. Read J,
and
we can take from the judgment.
No presumption.
No, I think, look, we read it.
Connection with the country.
Yes. Habitual residence, the label is not important. It's
Yes, that's right.
Yeah.
And
then re-NY.
well,
What?
forgive me, my Lord.
Yes.
Roman 10.
Yes, relocation.
Yes. Well, it's important for us.
It is important. It's there. It's an important issue.
And
If there's a genuine issue between the parents as to whether it's in the best interest of the child to live in this country or elsewhere, it must be relevant. It must be relevant
Yes.
whether the issue is capable of being tried to which in the country to which
if
the
there
child
is a
being
genuine
retained.
issue between the parents,
Yes.
that's the way it's put by Lady
Yes.
Hale. Not if the court decides on a broad brush analysis that there aren't substantial grounds for thinking it would be successful, but if there's a genuine issue between the parents. And at 11, the effect of the decision on the child's primary carer
Yes.
must be relevant, although not decisive. And then, in fairness, the observations about not standing in the way of a swift and unsentimental decision, but they may result in a decision that an immediate return would not be appropriate because the child's interests would be better served by allowing the dispute to be fought, as
Yes.
you put it and decided here. Then to re-NY, and my Lords, paragraphs 50 and 59 are the relevant passages for 12J, but my Lord, without reciting it again, that at little 2, the court ought to consider the evidence and decide what, if any, findings it should make in order for the court to justify the summary order, especially as it's put in relation to the child's habitual residence. So that's an observation, but that is in brackets because that was an Israeli case. And then third, in order to sufficiently identify what welfare required for the purposes of a summary order, an inquiry should be conducted into any or all of the aspects in section 1.3 of the 1989 Act, for the benefit of one of my lords, the welfare checklist of headline considerations in the Domestic Children Act 1989. A decision has to be taken on the individual facts as to how extensive that inquiry should be, but then it proceeds to Roman 4.12J. In a case where domestic abuse is alleged, the court should consider whether, in the light of practice direction 12J, an inquiry should be conducted into the disputed allegations, and if so, how extensive that inquiry should be, and that is paragraph 59. And that is, I think, the only mention of 12J within the four corners of this judgment.
How extensively was 12J advanced before the judge below?
I understand that it did form part of Mr. Jarman's submissions.
I don't think it's in his written submissions, so it must have been in his oral
think it
submissions.
is. May I just check? I know that there's been some interchange between Ms. Guhar and Mr. Jarman.
Right.
Oh, you haven't? I thought that had been written.
Don't worry. But anyway, what Lord Wilson says is the court has to consider, in the light of 12J, whether an inquiry should be conducted into the allegations. So, did the judge in this case consider whether an inquiry should be conducted into the disputed allegations? He did.
The judge decided that he wasn't going
Yes.
to hear oral evidence
Yes.
or therefore make any further inquiry, but he didn't do that with specific reference to 12J, where 12J had been brought specifically to his attention, and he...
You may have answered this while I was looking at something. How had it been brought specifically to his attention?
By his reciting into the judgment the relevant parts of NY. He, on the face of it, directed himself, because judges don't simply recite law for no purpose. They recite it to follow.
Yes, but is this submission, this can't be a submission that the judgment didn't contain a reference to 12J. It must be a submission that by not, say, going through 12J, his decision was in some way flawed. Is that right?
He, having recognised by quoting this passage,
Yes.
unless it's thought that he simply recited it without taking it on board at all, and we don't know, there's no evidence within the judgment as to whether he made his consideration, which was a determination not to take oral evidence and not to investigate, whether he did that in the light of practice direction 12J.
You're going to, at some point, show us how this was argued orally, because I appreciate that the court has to apply 12J if it's applicable, of its own motion. It wouldn't be dependent upon what was submitted to it. But I think it does help us to interpret your submissions to know whether Mr. Jarman said, these are the steps you have to go through under 12J, and the judge just simply went and did it differently.
I'm going to help as much as I can, but I fear that help may not be very effective, because although we asked for the transcript, we have not been able to provide that transcript, not for the want of trying. But, my lords, if the judge is alerted specifically to it, it's not a question, in answer to my Lord Justice Peter Jackson, of the judge having to do it of his own motion. The judge either alerted himself or was alerted to it by being referred to NY. And so he didn't need to go on a hunt for a needle in a haystack. He was told by Lord Wilson that in a case where domestic abuse is alleged, it was, the court should consider, in the light of 12J, whether an inquiry should be conducted. And that drew the judge inexorably, if he was being faithful to that provision in Lord Wilson's judgment, it drew him inexorably to 12J. And he didn't specifically go there.
I appreciate that. What I was trying to understand is, are you saying the omission of any other reference to PD 12J is itself an appealable error, or that the judge's analysis that he undertook was flawed, or both?
I'm certainly saying the latter.
Right.
In the absence of any reference to 12J, I might as well, my lord.
No, don't. Don't have to might as well.
Well, my lord, long ago, Lord Justice Thorpe, when I was reluctant to take a point, said to me, "You might as well take it."
Yes,
so that we
I
can
wasn't
litigate
inviting you
upon
to
it."
take it. I was
No.
just saying, I was trying to understand what your submission is. And I think I don't want to, because we have to look at the grounds of appeal. We have, and your case, as I understand it, is that the judge failed to undertake the required exercise, which if he had done, he would have decided that a fact-finding hearing was necessary.
Because he didn't make any reference in the four corners of his judgment
Yes,
to carrying out that exercise,
yes.
having alerted himself to the need for it, then we say the non-mention is an indicator that he didn't do it. And so
Not do what?
He didn't carry out the exercise in accordance with it.
Right.
In the
How
light
would you
of
describe the exercise in accordance with 12J, which he didn't do?
What part of 12J are you focusing on? Is it paragraph 16?
Yes, it is, Lord.
Right.
Right.
Court should determine as soon as possible whether it's necessary to conduct a fact-finding hearing in relation to disputed allegation of domestic abuse.
Yes.
And then it sets out 4 reasons for that.
Yes.
1, to provide a factual basis for a welfare report, etc. 2, to provide a basis for an accurate assessment of risk. 3, before it can consider any final welfare-based orders. And D, for domestic violence programme purposes. So really we're talking about B or C, are we?
I would add to that the observations, the core observations in HN, which read thus: the court will carefully consider the totality of 12J, but to summarise, the proper approach to deciding if a fact-finding hearing is necessary is, we suggest, as follows. First stage, to consider the nature of the allegations and the extent to which it's likely to be relevant in deciding whether to make, in the context of this case, a child arrangements order, and if so, in what terms. And this is where not only the summary return decision, but of course the decision on contact come into sharp focus. Then, in deciding whether to have a fact-finding hearing, the court should have in mind its purpose. As my Lord says, 12J, paragraph 16, which is in broad terms to provide a basis of assessment of risk and therefore the impact of the alleged abuse on the child or children. And then careful consideration must be given to 12J 17 as to whether it's, quote, necessary, unquote, to have a fact-finding hearing, including whether there's other evidence which provides a sufficient factual basis to proceed, and importantly, the relevance to the issue before the court, if the allegations are proved. And if I may, my Lord, because I'm going to come back to that. And under PD 12J 17H, the court has to consider whether a separate fact-finding hearing is, quote, necessary and proportionate, close quote. The court and the parties should have in mind as part of its analysis both the overriding objective and the President's guidance as set out in the road ahead. That's the law as it stands, I think.
Yes. Now, in paragraph 21, the judge carried out an exercise that I'd like to ask you the extent to which it bears comparison with a labelled 12J paragraph 16 order. And what's substantively different between the judge's approach to whether he heard oral evidence or whether he's carrying out a fact-finding hearing?
Yes. If I may, before I come to that, I will say a little bit about those considerations, and in particular about what was said in HN. And without going into the discourses in HN on the nature and effect of domestic abuse and coercive control, etc., including financial coercion and the like, there is abundant material to suggest that these do have, or are capable of having, a corrosive and long-lasting effect on primary carers and children, and that in circumstances, usually circumstances which relate to contact, because it's in contact cases that 12J considerations most frequently occur, it will very often be necessary to investigate these matters, even if it looks as if, for the moment at least, the flow of abusive behaviour has ceased. But, my lords, the observation about relevance in HN should be seen, we suggest, in that context. The reference to necessary in Roman 3, with a consideration of whether there's other evidence which provides a significant factual basis to proceed, and importantly the relevance to the issue before the court, if the allegations are proved, means we say that in a case where significant allegations of domestic abuse and coercive control are made, first of all, such allegations may increase and become more detailed and compelling in the course of the fact-finding itself, and that is something that is recognised, and one knows that in the context of H&N, attempts to shut down disputes of this kind were not necessarily regarded as being helpful or appropriate. Great care needs to be taken. So, my lord, if we go to the judgment, and starting perhaps, my lords, at paragraph 21 on page 63, there's the invitation for oral evidence to be heard, and the submission, as interpreted by the learned judge, was that credibility went to the heart of the decision of the court in this case.
Well,
of course,
just pausing on the previous part of that sentence.
Yes.
The submission that was made by Mr. Jarman,
Yes.
was that the court could not conduct a fact-finding here in relation to Mud's allegations of abuse.
Yeah. Well, my lords,
is there any doubt that that was the state of affairs?
that is what he said. But, my lords, that does not sit at all with the learning which the judge.
Yes, but I think we have to understand that there's as you might put it, one truth, but the whole of this appeal is premised upon a course submission which was expressly disavowed before the judge.
Amendment. My lord, as I understand it, Mr. Jarman's submission, although that doesn't come across necessarily from this passage, was that without a fact-finding investigation, the judge could not return. So, in other words, he is saying he agreed that proceedings were summary in nature and the court could not conduct a fact-finding hearing, but he was saying without a fact-finding hearing there can't be a return. With differing with deference from that submission, of course the judge could have held a fact-finding hearing, which might have been a very summary hearing, or it might have been a detailed hearing. He could actually carry out whatever fact-finding hearing he felt was appropriate and in accordance with the authorities that he himself had quoted.
Talking about the authorities, I mean, Mr. Jarman was your senior junior in NY. It's not that he's not familiar with this terrain.
Mr. Jarman's respect is not on trial.
No, I understand.
And nor am I think, necessarily going to answer for what Mr. Jarman said. Looking at the law, it is impossible, I think, with great respect, and I don't want to be critical of Mr. Jarman, but it's impossible to say that you can't have fact-finding in a summary return application. A judge may decide that he doesn't want to have fact-finding if he determines that in accordance with the directions in the guidance in Re-NY, and does so through the prism of 12J, well then that may be right. On the other hand, it is not impossible that a judge could say, well, what you've done is to present me with a summary return hearing. I need to fact find, and I take the view that fact finding is not proportionate to a summary return hearing. Therefore, I'm going to refuse the summary return, and this will go into a domestic welfare hearing where these matters can be adjudicated upon. But the more straightforward thing to do would be to see what fact-finding can reasonably take place within the envelope of the summary return hearing. And two of my lords will know that sometimes these summary hearings, so described, take a considerable amount of time and involve a deal of oral evidence, in contradistinction to the...
What I do know about litigation is that parties who take one position at first instance are not usually allowed to take a different position on appeal. So it seems to me to be quite important for us to know what the mother's position was. I'm not focusing on counsel, what the mother's position was on the issue of whether there should be a fact-finding hearing before a decision on return.
Yes.
You told us that you think that was Mr. Jarman's submission, but you don't have a transcript, and perhaps you could show us some, give us some information or show us a document that supports that position, because it's not in the judgment as far as I can see.
Indeed it is not. May I have a moment?
I think it...
No, that's...
Page 105 is the position statement.
Yes, page 109, paragraph 53.
Yes, that's...
The court is unable to make a return order on a summary basis without first having determined the allegations of domestic abuse.
Yeah.
I suspect what might have, the judge might be referring to there is the court, this is speculation, but the court at that hearing was not in a position to conduct a fact-finding hearing. Perhaps that's what...
I don't want to interrupt your lordship or learned friend, but the reference that you made should be read in conjunction with paragraph 34, page 105.
Thank you.
Just for completeness.
Yes, but they do square. Because
I'm not saying they don't square.
Okay.
I'm just saying that...
I think what Mr. Jarman was saying quite understandably is you can't determine these issues at a summary hearing, but you shouldn't make a summary return order until you have determined these issues. And those are entirely consistent.
I understand.
So looking at
which
the-
is what I indicated
Yes.
was the position.
quite. I've got your overarching submission is the judge should have undertaken a different factual investigation. What, speaking for myself, I haven't quite understood yet is why what he did do was an insufficient application of 12DJ and or H&N and or NY.
Yes. Well, my lord, what
Because it's all these that's why I'm picking out words like relevant. They're all factors, as you say, holistic. The court has to undertake a holistic evaluation, assessment, doesn't really matter what word one uses, for the purpose of deciding what is in the children's best interests. So it's targeting where the judge, it can't be matters really of weight, can it? Because matters of weight are for the trial judge. So it has to be a more significant omission, than that. Is that right?
If your lordships will allow,
Yes, of course I
in the
will.
time that I've got,
Yes,
I'll progress through the judgment,
please.
indicate where the judge
Went wrong.
made his determinations,
Yes,
and give our critique.
thank you.
Without, of course, doing it line by line. And so at the top of page 64,
Yes,
the judge, having said that he's got evidence of abuse, says, and in fact this is the bottom at 63, the allegations of abuse against the mother nearly all predate the separation, and the most recent and only allegation of significance after the separation is from 2019. That doesn't, my lord, give a correct recognition to the mother's allegations of a continuing coercive control, some of which were recent indeed. But, my lord, in terms of substantial incidents of domestic violence, that is undoubtedly correct. And then he said, I've evidence as to the effect of the alleged abuse on the children and the mother from Miss Baker and the mother herself. Well, limited evidence necessarily from Ms. Baker, and no oral evidence from the mother to expand in the way that one would expect on the effect on her. And then he says this, the court has to make a welfare determination concerning summary return, and the resolution of allegations of abuse is not required to make that determination, full stop. If that is an indication that in order to determine a summary return application, as opposed to this summary return application, well, of course, my lord, that is not right. He says, I cannot see any other purpose being served by hearing oral evidence from the parties, or how their credibility can be assessed, without determining issues which they dispute, so recognition of disputed issues, which in large part concern allegations of the father's conduct. But, my lords, it's not a question of conduct, and it's not a question of morality. It's made abundantly clear in NY and in the domestic abuse authorities that it's the effect of abuse on the children and the primary care of parent that counts.
You just referred to that.
Yes, my lord. It's
You
where he
referred
goes.
to cheek by jowl in the
It's
same
where he goes.
half paragraph.
What he then says is, the approach I take, borrowing from the approach in Hague Convention cases in accordance with RE, is I should make a reasonable assumption in relation to the maximum level of risk for the children arising out of any domestic abuse perpetrated by the father. I've been down that road extensively in the early part of our submissions with the court. I should in particular consider the risks to the children in the context of a return with any undertakings or pledges being formalised locally and bearing in mind the enforceability. Well, my lords, what does he do with that starting point? At 25, he looks at the welfare checklist and he says, I have to decide whether to order summary return or whether a welfare inquiry and assessment should be made whilst the children remain in this jurisdiction. Again, and with great respect to the point made in his recital of Mr. Jarman's submissions, he leaves out of account the middle possibility, which is that he requires a further investigation within the welfare proceedings and that he requires to carry out the evaluation commended to him in NY.
You've moved to a later stage in his reasoning, but in paragraphs 21 and 22, and that section of the judgment which you've analysed a moment ago, do you say that there's anything substantively different in what the judge was doing there to what he might have done if he'd labelled it as a 12J paragraph 16? If he'd said at the beginning, I'm going to consider fact-finding, and this is my conclusion on it, is that not substantively what the judge is doing, even if he didn't put a label on it?
Because he didn't put the label on it, then, my lord, we would suggest that he didn't have, at that stage in the case, fully in mind the considerations, perhaps, including those in H&N, about the full quality and nature of domestic abuse and its continuing effect.
So it would require us to find that this judge of the family division was insufficiently alert to the true significance of domestic abuse.
In this context, because what he directs himself about is the context of a summary return application. And there is no magic to the context of a summary return application in this regard. It's like a domestic case. What he certainly can do when making his evaluation in the light of 12J is to look at whether it's necessary, but he must not, with great respect to the judge, who is an experienced judge of the division, misdirect himself to think that there is some special quality to a summary return application. And even the warnings by Lady Hale in the now temporarily distant Re J indicate that judges shouldn't feel themselves rushed or bounced into avoiding welfare determination simply because it is a summary return application. But, my lords, in order to make that out, I think I should look further into the judgment, but that is the answer that I give to my lord's point. One moves to paragraph 25, and in doing so, doesn't jump over any findings by the judge, because that's a recital of submissions. He addresses himself to section 1.3, and he says, I have to decide whether to order summary return or whether a welfare inquiry and assessment should be made while the children remain in this jurisdiction. I've already made my comment upon that. That leaves out of account the middle course, which he should have undertaken. Such an inquiry would be likely to take many months. Well, my lords, with great respect, no, he had the ability to hear evidence there and then. He had the parties before him if he wanted to. And then he deals with a list of salient features. And of course, with many of those salient features, we can make no objection. What he says at paragraph 5 is, but for allegations of abuse by the father, which have only fully emerged since the mother retained the children after October 2021, there would have been no grounds at all for considering that relocation to England would be in the children's best interests. So what the judge is doing in a very, very summary way is purporting to analyse and give an evaluation of the prospects of success of a relocation application. We say that he could not, within the four corners of this, try the relocation application. He didn't have the material on which to do it. It wasn't case managed. What's more, the but is a very big but. Looking back at what is said in J, plainly there is a disputed issue between the parents as to where the children should live, and there isn't a relocation jurisdiction in Dubai. He moves on and deals with incidental matters which lead him to say that the children's position in England is precarious. He indicates that the children have started school in England and are doing well. They'd in fact spent 2 terms. They have few members of the extended family living here. In other words, they do have members of their extended family living here. The father is able to come here to see the children and have contact, and this is essentially, in part, a contact case. The home they live in is provided by the goodwill of the parental grandparents. Well, my lords, in Dubai, the mother is reliant entirely on the father's financial means. But, my lords, that's a balance which is not an adequate and full balance if it is carried out for the purposes of deciding what the merits or demerits of a relocation application are concerned. And his conclusion, the children's situation in England is precarious, is more appropriate, for example, to cases where someone is awaiting deportation, or has no home, or has no education, or has no possibility of a relationship with the other parent or with the family, or something of that sort. My lords, he then moves to abuse and says that, as he has said already, that the serious allegations relate to the period up to 2019, and then he says, since then, even taking the evidence at its highest, there is no credible evidence of domestic abuse by the father against the mother, and it all relates to past events. Well, my lords, that is not the mother's case at all, but is a determination. Even if that determination is right, then it puts out of account the lasting effects of coercive control. He goes on to say the allegations that the father has abused the children require some scrutiny, and that is an acknowledgement. The judge then makes what looks like an evaluative determination. In my judgment, reads like a finding. Both children showed signs of having been subject to direct and or indirect adult influence, and the adult question is likely to be the mother. Ms. Baker's observation that the origins of A's current hostility are uncertain belies the fact that it appears to have arisen or at least deepened significantly since October 2021. So, my lords, an acknowledgement that it has so deepened when A has been living only with her mother, and that the mother has been running a case that the father has been abusive. No evidence that the children suffered injury as a result of chastisement. Whether they say they were afraid of him, they don't appear to have shown any signs of emotional abuse, nothing from the school. And I've no witness evidence from family members or the mother's friends providing corroboration. So what the judge is doing is evaluating and making factual findings, in effect, about this. He is, again, we say, falling between two stools where he should have investigated further. He then concludes...
Sorry, this is all for the purposes of what? Saying the judge should undertake no evaluation for the purpose of determining either whether to have a fact finding or to make the summary return order, or that it was a deficient evaluation?
Well, let me proceed on the basis that these are referable to the question which Lord Justice Peter Jackson put to me, which is, and I hope I'll be forgiven for repackaging it slightly, did the judge undertake an analysis looking at necessity in the light of 12J?
Right.
What he's doing is something that is a little different. He is analysing, evaluating and minimising the nature, time and provenance of the allegations.
But he's giving his assessment of them.
But purporting to do so without fact-finding.
Yes, it all comes back to the fact that you say that fact-finding is mandatory and that the judge is not entitled to express any opinion at all unless he's carried out a fact-finding.
Within the context of the observations in 12J and HN, I did put that caveat. So at paragraph 9, the judge comes to his conclusion, I think. I do not believe that further detailed investigation of the allegations of abuse by the father will assist the court in making the decision about the return, even assuming, and here he is reverting to re-E, even assuming the allegations of abuse of the mother are all true. There are no incidents since 2019, and the mother would be in a more supportive environment in E than in England. Well, my lords, that's not her view of it, and not if the context is that there is substantial unsupervised contact with the father. On the mother's own case, there was not much contact between her and the father. I don't see her allegations as making out a case that the children are being significantly harmed by any ongoing abuse. Now, my lords, there, the judge veers into another piece of qualification. Significant harm is sometimes seen as a public law context in the public law aspects of the Children Act 1989. That, of course, is not what the judge is concerned with necessarily in a case of this kind. Equally, a grave risk of physical harm or emotional harm or an intolerable situation, a very high threshold, sometimes equated to that public law standard, and certainly gravity is often elided with the nature of the harm as well as the risk. Those are not, we say, material to the decisions on welfare which the court had to take, in particular looking as to whether to investigate further. So significantly harmed by any ongoing abuse of her by the father after separation. So he put as his yardstick significant harm.
You seriously advance the submission that the judge thought he was dealing with a public law case. Look at the next sentence.
My lord, I'm going to...
read in context. I mean, there must be a limit to the number of arguments that that we need to really focus upon. And I mean, it isn't suggested, is it, in the grounds of appeal, that the judge thought he was dealing with a significant harm threshold, that was one of the ways in which he misdirected himself?
The grounds of appeal provide a broader brush analysis and allegations, but my lord's significant harm is not, we say, what the judge should have been looking at.
But Mr. Secretary, going further down,
Yes.
the judge says, if the allegations of abuse of the children are all true, then they do not give rise to a significant concern that return
Yes.
would in itself put them at risk of harm.
Yes.
That's a different, so that's not significant harm, that's just saying there isn't a significant concern.
They're two different things.
They're two different things. So you have to read the whole, you can't just pick out random sentences and say, well, that looks as applying either the Hague Convention or public law. He then says, well, I'm looking at a variety of factors, one of which is, do the allegations, if true, give rise to a significant return that would put them at risk of harm? Is that a relevant factor for the judge to take into account?
With great respect to the learned judge, I would hesitate to say that these are random quotes from a judgment. It's a progressive analysis.
But is what the sentence I've just read out, is that a relevant factor?
That the allegations do not give rise to a significant concern. That is something that he could have looked at, yes.
Yes, thank you.
But that is different to the yardstick of whether they would cause significant harm.
I appreciate that.
Both are said, and whilst the Lord taking, of course, mild chastisement from my Lord Justice Peter Jackson,
rather than simply musing about this, are you saying that the judge actually applied a yardstick of significant harm?
that is what he said was.
No, I'm asking you whether that's one of your complaints about this, because I haven't so far read it being made.
My Lord, I can't explain what's said there, other than in its terms.
So you are saying that the judge misled himself, I mean, in fact, quite egregiously for a practitioner in this field, by imposing a yardstick of significant harm.
It may be, my Lord, that is not a fatal remark to the reasoning that follows, but I'm entitled, my Lord, with great respect.
Well, I don't think you are actually, Mr. Setright, entitled to trail your coat through a judgment in order to pick up points. You either have to make it as an argument, and we'll consider it on its merits.
It would be wrong, my Lord, to say that the judge had to look for significant harm. That would be wrong. That is not the test.
No, but do you say that that's what he was doing?
On the face of it, my Lord, he says it was not something that was present. That is evidence that would lead to him saying that there was significant harm, like ongoing abuse. It runs together. It's not only significant harm, it's ongoing abuse.
Thank you.
My Lords, he then says, however, while not condoning physical chastisement, the father's treatment of his children is not so concerning that it would preclude return. The allegations are all true. They don't give rise to a significant return. A return to E would itself put them at risk of harm in the future. Well, my Lords, again, we say that looking as the judge does at a risk of ongoing harm, puts out of account the ongoing effect of harm as widely recognised where there has been physical and non-physical abuse, which in this case the judge was accepting for the purpose of this evaluation that there had been. My Lord, at the top of the next page, 67, the allegations of abuse are an important element in this case, which is a concession by the judge, and is important if the judge should have looked at 12J. They are an important element in this case, but they're not so significant as to be determinative. Well, can the judge, we say, properly say that without investigating further? While the father disputes the allegations, I don't believe that making findings about the allegations is necessary. That is, one might say, apart from the findings that the judge had already made, which minimises them in some respect. Then there is a balancing, and paragraph 9, the children's relationship with the father and the destabilising of what was a stable family, school and social life in E has been caused by their retention in England without consent. That, my lord, leaves out of account any possible effect of the domestic abuse on the mother or the children. And then the court goes on to look at the circumstances following a return. And at paragraph 14, the judge, paragraph 13, the court recites the position of the children, a wish to remain in England, a significant factor, but their views, however genuinely expressed, have undoubtedly been directly and or indirectly influenced by the mother and by the circumstances of their retention and this litigation. Well, that's an area which the Kafkas officers, Baker, found difficult. The judge seemed to have made a very clear conclusion without hearing any oral evidence, in particular from the mother, on the point. 14, wishes against, a return against the wishes of the mother, cause upset to the children, and most likely for a longer period to their primary carer. However, there's no evidence that the mother or children have had any mental health problems or would be prone to such problems caused by an undesired return to E. Again, if the court had looked at the situation in the light of H&N and in the light of 12J, the question would not be asked whether there were any mental health problems, but whether the sequelae of the domestic abuse that had taken place, which had affected both the mother and the children, would have caused them problems or had a continuing impact on a return to the other country. Again, the judge there sets himself a rather narrow compass. He accepts the evidence at 15 of the Kafkas, of the expert, that some measure of protection of best interests would be offered by the legal system there. But, my lord, he then moves towards what was to become the content of the settlement agreement, and he recites the caveats to that jurisdiction. And then at 16, he deals with relocation. It does, he says, do more than give the court reason to pause. But in his judgment, the application would, even applying principles that would be applied in this jurisdiction, be very likely to fail. Well, my lord, I've made our critique of that and of his approach and of the basis, the very limited basis in which the judge purported to make an evaluation, that there weren't significant prospects of success. My lord, that without an investigation shouldn't, we say, have been his position, and it leaves out of account also arguments based on domestic abuse and control. My lords, he makes some further indications as to the material which would weigh against granting relocation. He adds finally, of more concern is that if circumstances changed so that it did appear to be in the best interest of the children to relocate, the courts of Dubai would still not countenance it, if the father objected and lived in Dubai? Well, my lords, the judge rightly indicates that there is a potential high relevance, and by implication, his evaluative analysis can't be a minority long analysis. He shouldn't, my lords, we say, have regarded the absence of a relocation jurisdiction in the context as being other than determinative. And, my lords, then he says, having
So you
departed,
say that factor on its own is
yes,
decisive.
that factor on its own, where there was an issue between the parties as to relocation, should have been decisive.
Well, it was bound to be decisive.
Should have been decisive.
Right, so
It's
I mean, it's clearly the point that caused the judge the most pause, because he says so.
it is.
But you say that actually everything else is, in a sense, by the by, because the absence of a relocation jurisdiction was in this case bound to be decisive.
In the circumstances. The circumstances including the critique of the analysis by the judge of prospects.
Of prospects.
Yes.
Thank you.
Then he gives what appears to be a rider to those headline determinations. He sets out the welfare checklist and then says these matters feed into the welfare checklist, and he deals with a balance in paragraph 27. Towards the middle of paragraph 27, he says, I do not believe that they would be at any greater risk of harm living in Dubai than living in England. Indeed, the harm from the emotional and geographical distance from their father is likely to be greater were they to remain in England. Taking the allegations of abuse at their highest, the children might be more at risk of harm from their father, whether in Dubai, and spending time with him more frequently. So he acknowledges that there might be a greater risk of harm if, as he says he did, the allegations were taken at their highest in Dubai. In England, the mother has no independent financial means and no home, save the one provided out of goodwill by the father's parents. I might add that in Dubai, the mother is dependent on the father also. The father has been, the mother has been failing to meet. I wonder if I might have a glass of water each. Is there one? Sorry, I'll continue. I don't know.
Are you sure?
Yes, of course. It's merely if I become indistinct, but time is extremely limited. Thank you very much. He says the father has at times been unkind, even abusive to the children, has failed to meet their emotional needs. The court can impose conditions on return to seek to protect their welfare. But, my lords, yes, but without investigating properly the impact on the mother and the impact of the children of the allegations, without acknowledging that they are longer lasting and more extensive than a cut-off point in 2019, without acknowledging the learning in HN, well, that is a balance that couldn't safely be drawn. And, my lords, as Lord Justice Peter Jackson rightly said with respect, it appears to have been the relocation that gave the judge the greatest pause for thought, which he goes on to at 29. In fact, it should have been the domestic abuse that gave him the greatest pause for careful consideration on a different basis to that which he embarked upon. And, my lords, I'm not going to add to what I've already said in the context of paragraph 29. And then he proceeds to make his determination and to the settlement agreement. My Lords, I'm sorry that I've taken a long time and I'm out of time.
No, we've asked you an awful lot of questions.
But it's right that your Lordships should ask questions and that I should endeavour to answer them, rather than my Lords simply having a skeleton and a wall of sound deposited upon them. But I wonder if the court will indulge me to see, because I said I'd finish at 1, to see what else there is that those behind and in front of me would invite me to say.
Yes, in a very short. Yes. Do you want to stop now, and we'll give you 5 or 10 minutes after the adjournment?
Well, that would be very kind.
I think we'll do that.
But without my, hopefully, taking advantage of that in any improper way.
Yes. So we'll adjourn now. Thank you.
Will you look up the room?
Okay, I'm going to lock the court and I'll be back again at 10 to 2.
Do you want me to bring papers out? But yeah, we'll see you back here just before you pop out and get something.
Can you just share the top on that this side and I'll put one on this side?
Sorry, straight my phone. Oh, after you.
Oh, thank you very much.